My name is Curry Stotner. I'm the Chief Learning Officer at the National Constitution Center, and today we are joined by Christopher Riano, who is the president of the Center of Civic Education. He's a constitutional lawyer. He has written an amazing book on marriage equality, and they can't wait to get started. And he's going to be led in this conversation by the CEO of the National Constitution Center, our favorite scholar in-house, Jeff Rosen. So Jeff, I'm going to turn it over to you. And if any questions, keep them coming. I will help you all out in the chat.
Thank you so much, Curry. Welcome, friends, and welcome, Chris Riano. We are so honored to have you. As our friends saw, we couldn't wait to start the conversation. You are the president of the Center for Civic Education, which is an amazing constitutional law and civic education nonprofit that, among many things, runs the We the People competition, which I'd love you to tell our friends about at the end of class. And you're a lecturer in constitutional law at Columbia, a constitutional scholar who served in New York state government, and you have a new book out, Marriage Equality from Outcomes to In-Laws, co-authored with Professor William Eskridge of Yale. You and I know that Bill Eskridge is one of the greatest constitutional scholars in America, one of America's great experts on marriage equality, as you are. And therefore, what I thought I would love our friends to come out of this class understanding is, what are the constitutional foundations of the Supreme Court's Obergefell decision, which recognized a right to marriage equality? At the time that the 14th Amendment was passed in 1868, the amendment was not interpreted to protect rights of dignity or autonomy that were broad enough to protect the rights of same-sex couples or even of LGBTQ equality. And yet in the 2015 Obergefell decision, the Supreme Court, in a decision by Justice Anthony Kennedy, recognized marriage equality as a fundamental right that extended to LGBTQ individuals. So tell us about how the amendment was interpreted when it was passed, and then take us up step by step to how we got to Obergefell.
Well, and it's an amazing question, and thank you so much, Jeff, because even just looking at that photocopy that we were mentioning, the idea that life, liberty, and property, as embedded in the Fifth Amendment, but also the 14th Amendment, play a crucial role in a human rights review and a human rights lens of the way in which a document like the Constitution protects fundamental liberties, protects fundamental opportunities. And what you can see happen when it comes to at least the LGBTQ rights movement, there's no question at all. Of course, George Washington and Madison weren't writing the Fifth Amendment and saying life, liberty, property, this is going to protect marriage equality, but yet it did in Windsor. And it did protect marriage equality at the federal level, as the Fifth Amendment would. And there's no question that the drafters of the 14th Amendment weren't thinking about marriage equality and autonomy and individual dignity when they drafted that in the 1850s. But that eventually did become the place where we hang our constitutional hat in America when it comes to fundamental questions, and particularly fundamental questions surrounding liberty. Jeff, as you know, and as so many people here know, we as Americans are very attached to that word. We as Americans have always been very attached to the concept of liberty. And there's something very special about it when it comes to thinking through, from a human rights perspective, questions that the government cannot get involved in, which has been interpreted to include marriage equality in the Obergefell decision.
Thank you for that great introduction and for helping us understand how that notion of liberty has become more, I'm going to use Justice Ginsburg's word, embracive over time. She used to talk about the Constitution becoming ever more embracive of the left out people, not just grudgingly, but with open arms. I'm going to go to the Obergefell decision, and Justice Kennedy identifies 4 principles and traditions that demonstrate that marriage is fundamental under the Constitution. And the first premise, he says, is that the right to personal choice regarding marriage is inherent in the concept of individual autonomy. And he cites the cases including Loving versus Virginia, which invalidated interracial marriage bans under the Due Process Clause, and the Lawrence and Texas case, which invalidated laws restricting same-sex intimacy. under the Due Process Clause. Tell us about this idea of individual autonomy and how cases like Loving and Lawrence located it in the Due Process Clause.
There's no question, and when we'd had an opportunity to talk with Justice Kennedy, there's really no question that he, as an individual lawyer, scholar in justice, has a very deep belief of autonomy, that government should, at certain points, be unable to be involved in decision-making opportunities that we have in life. And he most certainly feels that way when it came to marriage equality. And I think what's very interesting about that is if you were to take and take us all back to 2014, I don't know that everybody would have necessarily said that's the argument that's going to win the day. One of the things I often will tell folks and talk to folks about is the fact that the Equal Protection Clause often sounds, as well as in the 14th Amendment, often sounds a lot more easily usable in these instances. Equal protection, that sounds really good. But what's been so fascinating to see as the 14th Amendment has developed over the years is that it's this due process concept. It's the thing that Anthony Kennedy hung his hat on, that there are things in life that government should not be allowed to do, and that includes giving particular civil benefits to two individuals, no matter what their gender, and that the gender should not be something that they can make a decision or state can make a decision based on. And it's an amazing, I would say, almost hearkening back to these fundamental principles in law that at certain points, government should just not be involved in making these decisions in your life.
So let's introduce our friends to the best arguments on the other side, and then give them Justice Kennedy's response. Justice Scalia, in a series of cases, including the Lawrence case, said the Constitution doesn't contain the word autonomy. Until very recently, it was taken for granted that states could regulate health, safety, and morals. And the idea that you can't restrict conduct because of moral disapproval has no basis in constitutional text, history, or tradition. What was Justice Kennedy's response, and why did he reach a different conclusion?
I think in many ways I have a two-part answer. I mean, one of the things that I think was very interesting that we talk about in the book is that Justice Kennedy's mentor was a gay man that was the dean of his law school. Wow. And Justice Kennedy felt very attached, as did his wife, to this person. And
I didn't know that. Tell us more about him. Who
so the dean of Pacific Law School, wow, who helped bring Justice Kennedy in as a professor and was a huge mentor throughout his life, was an openly gay man in Sacramento. And as much as it made a difference in the LGBTQ rights movement to know people of same-sex coupling, at the same time, I have to say this, they clearly had, he revered that man. He thought very strongly of that man. That man had a huge impact on his life. And you could tell when talking with Justice Kennedy or talking with his wife about how much of an impact that had on his viewpoint. And at a certain point, Justice Kennedy, both in the LGBTQ rights space, but also if we can look even outside of that, and as you know, Jeff, individual justices have much more nuanced views than it may seem on a single case. He felt very strongly when it came to LGBTQ rights that the government shouldn't be restricting people. That happened when it came to Lawrence and it came to sodomy laws. That happened in Romer v. Evans when it came to anti-discrimination statutes in Colorado. That happened again in Windsor when it came to Edie Windsor and her challenge to federal laws here in because her wife died and didn't want to pay taxes. And it happened in Obergefell when Justice Kennedy wrote what is truly, I think, his ode to this amendment and how he feels so strongly about what the 14th Amendment says about America and why the 14th Amendment has had and has such an impact on America.
That's absolutely fascinating about that influence of that mentor on Justice Kennedy. Can't wait to read your book, and friends, I know you'll want to read it too as soon as it's out. But let's just take one more beat on this, because I understand Justice Kennedy felt very strongly about this as a matter of principle and his own sense of morality and justice. He thought discrimination was wrong and autonomy was wrong. But what's the constitutional foundation for autonomy? I'll share with you that in preparation for this class, I was talking this through with my kids who are ninth graders. Yeah. And I said it was a kind of, as best as I could state, it was a kind of natural law argument that said, and this was my effort, and you'll do much better because you're the world expert, but I said, if freedom of conscience is a natural right, which the framers all believed it was, because we can't command ourselves or anyone else to think as we please because our opinions are based on reason, and which can't be alienated. Therefore, I can't impose my morality or my conception of the just on you because your conscience is yours to determine as you please, as long as your actions don't harm others. That was an attempt at it, sort of locating it in that idea of the natural right of freedom of conscience. But how would you state the foundation for this natural right of autonomy?
Oh, I love that question because I think in so many ways, as we know, when we think about what is the law, right, we unpack whether there's these natural laws, natural rights, right, where it all starts. We unpack the idea that we create laws, positively create them, whether it's a constitution or a statute. And then we obviously have to think about realism. And one of my favorite parts to tell in the story of the 50-year history of marriage equality are the legal realism moments where people changed their opinion. So I can even think of one of the judges that I worked for, I think is the only judge in America to have written an anti-marriage opinion and then later written a pro-marriage equality opinion. Oh. And he would be the first to say, I just looked at it differently. That realism is baked into our constitutional ethos. And I think that's actually something that's really extraordinary because it allows the document to match the moment, but it also allows for the important concepts of precedent and other, ideas to maintain a steady hand on where the law is. And I think it's amazing that you spoke, Jeff, with your kids about that, because the number of times I had stories of state lawmakers or others who were so conflicted about what to do in their state when marriage equality came up on a state level. And the number of times the change happened because of a conversation with people's kids is extraordinary. It's extraordinary to see how, as much as we, when it comes to constitutional law and civic education, I'm the biggest advocate that says that's a lifelong journey. It starts when you're young, it goes all the way until you're old. And it's one of the beautiful things about our field. It's something that makes me very proud to be a part of the civic and constitutional education space. It's very different than other areas of law.
So true. I share your pride and that sense that it's a lifelong journey always requires testing, learning, growing, stretching, and reading above all. You just said something really important about realism. And you suggested to a certain degree, and Justice Ginsburg has suggested this too, courts are mirroring changes in society's understanding of the Constitution. Justice Ginsburg said, taking the measure not of the passions of the moment, but the considered opinions of the hour, or something along those lines. So it's not like judges are taking polls, but as society came to view restrictions on marriage rights as unequal and an offense against dignity, so the courts mirrored that change. Is that a fair statement? Is that a legitimate way for courts to decide cases?
I think if anything, it's both a fair statement, and I'm going to let everybody in on a little secret. Before Obergefell went up to the Supreme Court, there was another case that came out of the Fourth Circuit, and it was stayed among with other federal cases at appeals courts, and they were all stayed, and there was a vote taken, and we talk about how the vote came down in the book. And the vote was to lift the stays and not accept cert and take the cases. And like that, over half of America, because of the federal judiciary, had marriage equality everywhere from Colorado to South Carolina to West Virginia. And it's that moment. It was by not acting that the court showed, as you know, Jeff, that the court showed that's when marriage equality was going to happen. And it's incredible to see that. It's incredible how the not deciding of a case can actually pave the way. And that's one of the most realistic things you can see, because there's no decision on that. It's a decision to not take the case. And to have seen the dozens of federal judges who up until that point had almost ruled uniformly for marriage equality after Windsor shows exactly what you just said about Justice Ginsburg, that there's a lot more moving pieces to this often than there may seem. And it's often in cases where they don't act at the Supreme Court level that and other judges have, where change is possible.
Completely fascinating. It's so important to point that out. Adele asks a great question. What's the tipping point of the dynamic of the law's steady hand and involving changes in attitude? And I'll just tee that up with the excellent question with the fact we've talked about natural law as one basis for the autonomy right. Another is history and tradition. And is it right that courts do look at shifts in history and tradition? They'll count up how many states recognize marriage equality in deciding whether or not there is a consensus among the traditions and history of our people, to quote Justice Cardozo, recognizing a certain liberty right. So a court's decision to stay its hand and to allow state recognition of marriage equality to go into effect could affect that tradition. Say more about that and whether that's a legitimate way to decide cases.
Oh, I think tradition's critical. I think tradition goes at the very heart of not just our written constitution, but our unwritten democratic norms. And there's a lot of things that we as Americans do that are our norms as part of our democracy that aren't necessarily written down and that form a really solid basis for how our republic and our constitutional republic operates. And those norms are crucial because they set the tone, even outside of our written documents, for how we're going to process looking at change. And those are based on precedent. They're based on the, the way we've done things before. And I think that's actually one of the beautiful things about this is it's not necessarily as easy to simplify, even if we wanted to say, this judge feels one way, this justice feels a certain way, this legislature feels one way. It's actually all of that. That's what makes the system both sometimes hard to understand, but that's actually the beauty of the American Federalist model, that you can have marriage equality in Massachusetts in 2003. And that can be there for almost 20 years, or almost 10 years, until you have marriage equality across the land. That even after marriage equality in most states in America, until last spring, you could be fired just for putting a picture of your spouse up on your desk. It's amazing to think about that. That's still a part of this rubric. Now, there's a lot of questions on how that looks, but those norms are really important because they guide our conversations, and they most certainly guide the way in which courts, legislatures, and the executive branch look at how to decide on questions that can be evolving in our democracy.
This is so illuminating. You're telling us how courts actually decide cases, and we're also rooting this in the various methodologies of interpretation. In this case, as you just said, tradition and history, which evolves. Now, let's talk about precedent, which was another mode you mentioned. So, friends, just to review, because I know we're going through a lot, we've talked about natural law, we've talked about history and tradition. Now I'm going to ask Chris about precedent. There are a whole bunch of precedents cited in the Obergefell cases. We've already talked about the autonomy cases, Lawrence, Griswold, the Casey versus Planned Parenthood decision, which struck down restrictions on reproductive choice. But there's also a series of equality decisions. You mentioned the Equal Protection Clause, and the Romer v. Evans case said that you can't pass laws based on animus or hatred or dislike of the group in question. And from that, it seemed to derive a broader right of dignity. So tell us about how that right of dignity is rooted in the Equal Protection Clause in cases like Romer.
Oh, that's a beautiful question. And there's just so much that is incredible about the Equal Protection Clause. It's when you look at where it started and where it comes from, and a lot of the language that exists around going into the 14th Amendment, there's a very different view that folks had about what this would do, about how it would break down different group systems to make sure that everybody was being treated equally. And there's a lot baked into that word equal. But what you find over time is that the way in which that question has been actually realized in courts is very, very different. It's one of the reasons why, we can look at the fact that the Equal Protection Clause treats women different than it does the LGBTQ community, different than it does immigrants, different than it does race. And you can take a word like equal and yet make it very unequal just by the way in which it's been interpreted, which I find fascinating. And instead, we bake so much of that equality into the word liberty, into the word life, into words that don't necessarily seem to fit that rubric the same. And there's no value judgment. I just think as a scholar, it's a fascinating thing to see over time. And I think it shows up very much so when it comes to looking at Romer, when it comes to Obergefell, because Justice Ginsburg was adamant that Obergefell not just be Justice Kennedy's liberty argument, but instead she wanted to see the Equal Protection Clause very much in there. And that paragraph is definitely in there. And there's a reason for that from the former justice. And I think that's one of the things that's so fascinating, is to see both how they play together, but they're not the same. They're not the same legal concepts.
That is so interesting. I didn't know that. And I'm finding the paragraph now. And is it the one where she cites the MLB case? It says, recognizing new insights and societal understandings can reveal unjustified inequality within fundamental institutions that once passed unnoticed and unchallenged, and this court has invoked equal protection principles to invalidate laws imposing same-sex-based inequality on marriage. See Kirschberg and the MLB, which was one of Justice Ginsburg's favorite cases. Is that the right paragraph? And tell us more about
I believe so, yeah.
Wow.
Yeah. I mean, that's part, it is the story of marriage equality starting in 1967, thinking about how Loving versus Virginia had made a fundamental shift when it comes to making sure that people of different races could get married, and the way in which that arc moved so fast and in so many ways, and how it was people of color who filed the first lawsuit in Wisconsin, federal lawsuit, arguing under the 14th Amendment, and how the arguments there radically changed over time as more and more people became more and more understanding of why marriage equality was a constitutional right. It's an incredible story to tell. It's an incredible group of stories to tell. And what it does is it tells the story of America. And it tells the story of social justice. It tells the story of racial justice. And it's a really amazing way of looking at the way in which the different branches of government operate.
That's amazing. We jumped right in at the end, and I want to go back to the beginning in a sec, but just as we run through the various modalities of constitutional interpretation, natural law, tradition and his precedent, natural law, history and tradition, precedent, including the equality precedents. We have the obvious question, and it's a good one. It comes from our friend Warren Wolf. We'll square all this with textualism and originalism. If you're just looking at the text, the word autonomy and dignity don't appear. And if you're looking at original understanding, as you began by discussing, obviously the framers of the 14th and 5th Amendment did not mean to include LGBTQ equality. So can you be an originalist and also recognize the right to marriage equality?
Absolutely. And I think you can show that through the way in which the Equal Protection Clause was incorporated and the way in which the Ohio Constitution of 1851 served as the backstop for why they put the Equal Protection Clause in the 14th Amendment, and the original public meaning of the Equal Protection Clause would have eliminated all of these different category-based systems and said that based on incorporation, we have to treat everybody equally, and the states have to too, right? Because the 14th Amendment's big shift is it took what is now on the front of the National Constitution Center, Congress shall make no law, right? And it said, not just Congress, the states shall make no law. And the incorporation of the Bill of Rights, the way in which it fundamentally altered that dynamic, and the way in which the original public meaning of the 14th Amendment and the Equal Protection Clause is absolutely something from an originalist standpoint that you could say, this is where dignity comes from. This is where autonomy comes from. This is where equality comes from.
First of all, thank you for the shout out to the fact that the First Amendment tablet's coming to the National Constitution Center. We're so excited about that. And we're going to all celebrate that soon. But this is so important that I want to make sure I understand it. So I think I'm going to ask you to run through it one more time, because tell us what the text of the Ohio Constitution was. And you just said it, but I want to make sure I've got it. Why does that protect the rights of equality and dignity?
When you look at the arguments that were going on during the discussion about whether to put the Equal Protection Clause in the federal Constitution and the borrowing of the equal protection language from the 1851 Ohio Constitution, you begin to see that the idea, and we argue this in the book, was that the Equal Protection Clause's job was to break down caste. Its job was to break down difference. Its job was to remove those opportunities in government, not where we are now, where we kind of layer it in different ways. And that's the original public meaning. You can see that in the arguments that people made for why that ended up in the 14th Amendment. And so there's a very conservative, very libertarian argument to be made that, yeah, marriage equality was baked in all the way back then. We just didn't see it at that point yet.
Wonderful. Now I've got it, and it's so important. I'm glad I asked again. Friends, a crucial word that Chris just used is caste, C-A-S-T-E, caste, meaning a hierarchy. Some people are better than others. And he's absolutely right. I will learn from his book about the Ohio Constitution, but people stood up during the debates over the 14th Amendment and said, this amendment is to eliminate class legislation and ensure that there is no caste in America. They said it again and again. The point of the amendment is to eliminate caste. And then Justice Harlan, in his Plessy versus Ferguson dissent, said the point of the amendment, the Constitution is colorblind and neither knows nor tolerates classes among citizens. There is no caste here. So Chris is absolutely right. He's teaching us that central original public meaning of the amendment was to eliminate caste-based distinctions, and to the degree that restrictions on marriage do that, signifying that some folks are less equal, less deserving of dignity than others. They're caste-based distinctions that should be struck down. Okay, wow, that is really, really helpful.
Yeah.
Friends, as you've listened to Chris, and we're incredibly privileged to have his insights about the various constitutional foundations for this decision. Make up your own minds. Which of these constitutional approaches do you find most convincing? Natural law, history and tradition, precedent, text and original understanding. And of course, it depends on what level of abstraction you interpret the original understanding. If you're just asking, what do the people who passed the amendment think? Well, you might not get to marriage equality. But if you're examining the broader purpose of eliminating caste, then you might get to Obergefell. But you read the opinions and the dissents and make up your own minds. Okay, this time is so precious, but I'm sure there's so many gems in your book, like the fact that Justice Kennedy was so inspired by this mentor. What else can you share with us about just the history of the struggle for marriage equality, during that 30 or 40 year period that you think our friends should know about?
Absolutely. And I'll say this, I think it's one of the most intersectional movements that we've ever seen. I think that it's extraordinary to see the successes that happened, the failures that happened. I think it's really amazing to see how government really showed its interactions when courts did not move marriage equality forward, when people moved it forward in the legislature, when executives took charge and moved forward on making sure that there were opportunities for partnerships. And it's changed family law, it's changed constitutional law, and it's changed religion. I think that's one of the things I'm really amazed about with the book. The opponents of marriage equality have been just as out there talking about the book as the proponents of marriage equality. So I'm very proud of Bill and I for hopefully at least getting that balance right and telling the balanced story, because I think that's an important thing to do. And it shows why this movement was successful. And from a constitutional scholar's perspective, it's the very definition of our Constitution to see something like this happen and to see when it had to happen in the legislature, to see when it had to happen in the judiciary, to see how they would frequently interplay with each other. And we now live in a world where there's a menu of different relationship options that are available to opposite sex couples. In fact, California just expanded their domestic partnership law so that more people could take advantage of it if they didn't want to necessarily enter into a traditional marriage structure. And it's amazing to see how that happened. And it's amazing to see the change over time. And it's also something that there's so many other issues to think through when it comes to the LGBTQ community, and also the 14th Amendment and what a crucial role it plays in our society.
Amazing. I always have to turn back the mic to Curry with reluctance because I've got so many more questions, but I know she's got questions from our friends, and back to you, Curry.
Yeah, I was like, I'm never getting in. But it's really fascinating, and I've been enjoying it back here and quietly smiling the entire time at the interesting questions and dialogue that the students are coming up with as well. So some of the questions that have come through, Aaron Hull asked, is there a movement looking back at the plurality of marriage? So more than one marriage, would that be a way that would be interpreted in a different way of like the future of marriage? And wanted to kind of ask you guys about that. He's one of our teachers in our TAC and wanted to understand that as well. And then I have like four more questions. So you got a lot coming.
No, it's fine. I can say very quickly, because I think that this is a fascinating American experience. The judge that ruled in the case that eventually went to the Supreme Court in Obergefell at the district level in Michigan, very conservative judge. His first law clerk was a lesbian woman, and they had a kid while she was clerking, and totally changed his mind about the LGBTQ community. And she got the first case in the country with that question. Fascinating. Wow. She actually had the first federal case on that question. So in many ways, I think, no, not necessarily, but what you do see is you see a menu of relationship options now, domestic partnerships that otherwise wouldn't have been available, civil unions, structured, registered unions that you can put together. And what it does is it allows people to ensure that same sex or opposite sex, you can construct what's really among your most fundamental core relationships in your life in a way that is most beneficial to you.
Awesome, thank you. Mira wanted to understand the caste argument. And so, Jeff, you talked about Harlan, who you know I'm obsessed with, and other people, but have we seen that in other cases in United States history? Sorry, stumper. I loved it. You can ponder as we go to the next question. Have we seen
Chris, you were telling us about how that was the central argument in Congress, and Justice Harlan did pick up on it as Plessy dissents, but when did it first start to get traction in majority opinions in the court? The Brown court didn't really own it as directly as it might have.
Right, I would say that too. And in some ways, it has a similar tortured history to the to some of the other parts, like the privileges and immunities questions that come up in the 14th Amendment, which are all over the place and suddenly very popular sometimes. And then other times it's like those words don't even exist in the document. That's actually really interesting. I would say post-Brown, especially when I think a lot more civil rights cases and civil justice cases and social justice cases began, people were hanging their hat on the 14th Amendment more and more and more and more, especially because of the success that happened in Brown.
And so Talib wanted to like clarification, when they put this idea of caste in, and Harlan speaks of it, is this during that time period, it is speaking about enslaved African-Americans being put in a caste, or is it thinking about all different kind of groupings of people, just for clarity, so we understand what were they talking about then? Because I know when you read the whole dissent from Harlan and all of the pieces, you don't hear that kind of protection of caste in all that he says.
I recall the language surrounding the 14th Amendment and the idea of caste and not having a caste-based, breaking down caste-based systems as being very inclusive and being very, very expressive as to this really is for race, but it is also for anybody who would find themselves in a structural caste-based system. That's my recollection. I have to go back and read it again, but that is in my mind.
Absolutely. And Chris, you're so right. And women's suffrage advocates invoked it as well, not successfully, but they also said you're subordinating women by putting us in a caste-based relationship. And the framers of the 14th Amendment kept saying, this isn't just for African Americans, it's for all people, including, white laborers and stuff like that who'd been disadvantaged after the Civil War. So that anti-caste principle is so broad. But what Chris just taught us, we have to go back to the original sources, because these principles, popular at one time, just completely fade from the national debate, and then they're resurrected a century later when people come to recognize their power. Absolutely.
So that will be our Chris work for the weekend. So that's what we call it. We usually call it Jeff work, but you assigned that one. We'll be
supposed to be fun homework that you do voluntarily because you want to learn more.
Right.
If we make it sound better, it is better.
Well, the Chris work is to read Chris's book as soon as it's out. So that's what
Okay, so one more question from Mark Thomas. So why hasn't the court relied on privileges and immunities clause in their decisions? So a great question. If you need to talk about Slaughterhouse, you feel free. You can talk about Slaughterhouse too.
I will actually even go further than that. I would suggest reading some of the more recent dissents from some of the justices about that clause. And I'm thinking Justice Thomas, and I'm thinking a couple others, and see what their arguments are, because I think they're very informative as to the viewpoint of why the P&I clause has somewhat fallen off the radar, and why Justice Thomas, I would probably argue, would throw a lot of what we're talking about from other parts of the 14th Amendment into the Privileges and Immunities Clause and say that that's really the place you should be looking for these types of liberties. And I think that that's a matter of constitutional interpretation, but I would almost say that some of the more recent arguments in those dissents are more fascinating, or a more fascinating way to get at that answer.
That's fantastic.
That's such a great suggestion, Chris. That just sparked all sorts of stuff I want to read too, because I think you're absolutely right. Justice Thomas's robust conception of privileges or immunities might include common law rights that the framers thought were protected by the P&I clause, including possibly the right to marry, although he dissented in Obergefell because the P&I clause wasn't there, and a much more robust right to contract and economic liberties than the current court is willing to protect. So what you're reminding us is the virtue of rediscovering forgotten texts and of thinking creatively about how to apply constitutional text, history, structure, precedent, tradition, and natural law in light of new circumstances. This has been a constitutional feast, to use Robert Bork's phrase, and we're all learning so much.
We did talk in the beginning, Jeff, before you got on, that the 14th Amendment was like a smorgasbord of all these ideas. Well, I didn't think you'd love it, but now thank you for making me work that in. So I appreciate that. And on that beautiful note of this cornucopia, maybe that's a better way to call the 14th Amendment, a cornucopia of ideas and conversations and understanding over time. I wanted to thank you, Chris, so much.
Thank you.
I absolutely love that you're in the civic ed field, that you're bringing all this brilliance of the law into the civic ed field, and you're also as excited about this as Jeff and I are. So all these things together, thank you so much for joining us in class today.
And I'll say thank you too, Chris. Just thank you for shining your light, for inspiring our students to learn more about the 14th Amendment, for casting light on the history of marriage equality. And I'm so looking forward to the work of our two organizations together to inspire people to learn about the Constitution. So
as am I, and thank you for having me. This was wonderful.